more on this, we are joined in the studio by Ulrich Roux, who is a criminal law expert. Ulrich, thank you for your time today.
Thank you for having me.
So a lot of views coming through. I mean, you heard I was reading some of them, but perhaps let's go to what the law says. According to Manja, there says that the onus is on the state, but if it cannot be proved without a reasonable doubt why the accused is not at court, then the warrant cannot be issued. Tell us more about that.
I think the most important point that we need to remember, and that the public out there needs to remember, is that a warrant of arrest has been issued for Jacob Zuma, but that warrant has been stayed. That means that the warrant is not active. So if he does not appear on the 6th of May, which is the next appearance date, then the warrant will only be activated. It will be made active. So there's no warrant of arrest currently for him being circulated to border posts and to the police to arrest him. And I think people must be very clear about that. Now, the reason why we do that in our criminal justice system is because if a person does not attend to court and he has valid medical reasons or valid reason, in this instance it is a medical reason, his legal representative submitted to the court that he's actually in Cuba receiving medical treatment, but there's not sufficient evidence at that stage, then the court issues the warrant, but the court stays the warrant. So if he does not appear on the 6th of May, and he does not produce the evidence which proves to the court that he was indeed sick on the previous occasion or unable to appear because he was receiving treatment, then only the warrant will be issued. If he does produce it on the next occasion, then the warrant will merely be cancelled and the matter will proceed as per normal.
So what is Judge Pillay actually communicating? Is he saying, yes, I believe you? Or is she saying, I believe you, to the extent that more evidence is presented to me? What is the message that has been communicated by this stayed warrant of arrest?
Well, we must remember that Jacob Zuma's legal representative is an officer of the court. So on the face of it, the judge must take what he says to her as being the truth. Now, here she said that you are making these allegations that he is receiving treatment in Cuba, that he is ill with a specific illness, but the evidence that you have adduced has not convinced me entirely, and on the next appearance you must adduce further evidence and proof which will confirm to me that that was in fact the case, and then I will cancel the warrant. The logistical effect of this is purely that this is a way for her to ensure that on the next occasion he is there, and then to prove to the court, well, this is the reason why I was not at court on the previous occasion, and as I said, then the warrant will be cancelled.
Let's talk then, Ulrich, about what actually is admissible in the courts of law as far as medical proof is concerned. What was presented is what looked like a medical letter. Something was presented. What is it that will make this legitimate? What is it that will make Judge Pillay truly believe that this is admissible as part of the evidence in the court?
The easiest evidence that the defense will be able to adduce, which will confirm that to the judge, is if the doctor who deposed to that letter comes and testifies in court, him or herself.
But is that standard practice?
Well, it could be.
On
a daily basis in our courts, when a person cannot appear in court, and his or her legal representative adduces evidence, the state can either accept that and not apply for warrant of arrest, or the state can say, no, well, we don't agree with this, and we find that this letter has either been changed or altered unlawfully, and accordingly we are not accepting that this is a truthful letter showing that he is receiving medical treatment and he cannot appear, and thus the defense must be called upon to come and adduce evidence to show to the court that beyond a reasonable doubt this is a medical letter deposed to by a registered doctor with a valid practicing license, and that the court must accept the letter and the evidence of the doctor to say that the person who was supposed to be before court cannot be here because of the following medical reasons. So it's never a clear cut whether it's accepted or not.
Is it always then in the jurisdiction of whichever judge is sitting, they can decide whether or not to accept?
Indeed, it is completely at the judge's discretion. If the judge, and in this instance, from what I've read in the reports, it says that the judge received the medical letter, but that the judge had her own concerns. There were certain words that had been crossed out and changed to other words, which is on the face of it, it does indicate that the letter has been altered. So the judge could very well insist that the doctor does come and testify to prove that that is an original medical letter.
Before we go for a break, just really quickly, one of the members of Jacob Zuma's family came up and said, but he has been diligent in attending court cases. I mean, all the way back, from 2005, he's attended without fail, and he misses one court appearance for what they say is a valid reason, and then he gets issued with a warrant of arrest. How does that work?
Well, that unfortunately is what our law states.
So precedence does not matter?
No, not at all. The fact that he appeared for the last 10 years means nothing. If he misses a court appearance, then a warrant for his arrest is issued. In this instance, he had a valid reason, but the judge has said, I'm still issuing this warrant, I'm staying it, come and prove to me on the next occasion that this is a real medical letter and that you really did receive the treatment. And then the warrant will be cancelled.
Ulrich, thank you so much for your time, giving us a bit of context there regarding the legal issues on the warrant of arrest that has been issued for former President Jacob Zuma. But a very important point to remember is that it is stayed until the 6th of May. So should he not appear in court on the designated date, then it will in effect be issued and it can be acted upon. So